may want to make sure that microphone is on and close to you.
I believe it's on.
There you go.
There we go. Okay. Mr. Chairman, Ranking Member Conyers, members of the committee, my name is Elizabeth Price Foley. I'm a professor of constitutional law at Florida International University College of Law. I'm absolutely honored to be here today to talk about this topic. I've provided the committee with what I consider to be a roadmap of how the House can establish standing to sue the President as a means to enforce his constitutional duty to take care that the laws be faithfully executed. I believe Congress would, in fact, have standing to sue the President to enforce his duty of faithful execution, provided a four-part test is satisfied. First, the institutional injury alleged should be one that can be characterized as a nullification of a legislative act. The Supreme Court in Raines v. Byrd made it clear that if members want to assert an institutional injury, the Executive's act must effectively nullify a prior act of Congress. So, for example, if Congress declares X in a law, a nullification would be an executive act that effectively declares not X. So, let's say Congress passes a law that says anyone who enters this country illegally shall be deportable. An executive act that declares a group of illegal immigrants not to be deportable would be a nullification of that law. Say Congress also enacts a law that says it shall, in fact, go into effect in 2014. An executive act that says the law shall not go into effect in 2014, but instead 2015, 2016, or whatever, would also clearly be a nullification. Second, the lawsuit should be explicitly authorized by a majority of the House. This is because the case law indicates that when members assert an institutional injury, we have to make sure this is not a sore loser lawsuit that's brought by sort of an ad hoc, disgruntled group of legislators. Explicit authorization for litigation is critically important because what it does is it signals to the court that the institution as an institution believes it's been injured. Third, the lawsuit should target the President's what I call benevolent suspensions of law, which means that there would be no private plaintiff available to adjudicate the constitutionality of the President's acts. A benevolent suspension of law is when the President grants a privilege or a waiver from the operation of law to a certain group of people that, of course, the President himself defines. So, for example, when the President delays various provisions of Obamacare but not other provisions, or he decides not to deport some young people who've entered this country illegally, he benevolently has suspended the law with regard to that group of people. In these situations, the individuals aren't sufficiently harmed to satisfy personal injury requirements of standing. In fact, no individuals are. Think about it. When you delay an employer mandate to provide health insurance, when you decide not to deport certain young illegal aliens, these actions undermine our laws, certainly, and our constitutional separation of powers, but they don't hurt any individuals enough to allow them to challenge the President's acts. In fact, if the constitutionality of benevolent suspensions of law is ever going to be resolved, it must be resolved through litigation by Congress against the President. Fourth, the lawsuit should target presidential acts for which legislative self-help is not available. The reason self-help is salient to the courts is because they want to make sure that Congress couldn't just simply undo the executive's act by a simple majoritarian vote. But think about it again. When a president fails to faithfully execute the law, there is no simple majoritarian remedy available. Because what Congress wants in this situation is for the existing law to be enforced. Repealing a law that the Congress simply wants executed is obviously not a remedy here. Congress also couldn't enact another law in this situation because it's already enacted the law it thinks it wants. Congress, again, wants the existing law to be enforced. We shouldn't also have to resort to the drastic act of impeachment. Peaceful court resolution is going to be a lot easier here, and I think that's what the courts would find. What Congress wants here, again, is faithful execution of the law. It may not think that the President should be entirely removed from office. It just wants the President to faithfully execute the law. Peaceful resolution of disputes between Congress and the court and the president has been accepted by the courts since Marbury versus Madison, and faithful execution of the law's disputes should be no different. Separation of powers is clearly a critically important principle, and I think it's something that all members of Congress, regardless of political persuasion, should want to see preserved. In the case particularly of benevolent suspensions, the only recourse, again, is for Congress to seek a court's declaration of the constitutionality of the President's acts. These are serious constitutional questions. There's reasonable arguments on both sides. They deserve a full and fair hearing in our courts of law. Thank you.
Thank you, Ms. Foley. We will now begin questioning under the 5-minute rule, and I will begin by recognizing myself. Professor Turley, many of the unilateral actions the Obama administration has taken addressed controversial political issues, effectively cutting the people's elected representatives in Congress out of the political process for a whole host of important issues. What is the effect on the political process of having the executive branch alone make these tough decisions? Is unilateral decision-making good for our Republican system of government?
Well, thank you, Mr. Chairman. The greatest danger that we have really cannot be overstated when you have the concentration of power in one branch. That is precisely the danger that the framers were seeking to avoid. People like James Madison viewed the branches as sort of like bodies in orbit. They were locked in an orbit of shared powers. Once you have a concentration of authority in any one branch, it creates instability. But what people often miss is that separation of powers is really not about protecting Congress, about the institutional powers. Separation of powers was designed as a protection of liberty. It was to prevent the concentration of power by any of the branches that would threaten individual citizens.
Professor Foley, can you elaborate on what long-term institutional consequences would likely be if the current practice of benevolent suspensions of the law isn't stopped?
It's a really good question, because I think, if Congress can't stop the president from these benevolent suspensions, I think the first thing that occurs to me is that people are going to become very cynical about government. They already are, but it's going to get worse. And particularly, I think people are going to get very cynical about the Constitution. They're going to start thinking that law is politics. I already have students in my classes who think that, and it gets worse and worse every year because of situations like this. Situations like this, these benevolent suspensions, as they get more and more frequent and more aggressive, they're eroding our citizens' respect for the rule of law. We are a country of law and not men. The other problem I would see from your perspective, if I were sitting on the other side, is that, it's going to render Congress superfluous, right? You have a delicate situation here, I understand, but think about whether or not you would ever want to tackle any super controversial issues if this continues. Because think about, for example, comprehensive immigration reform. Why would you go to the trouble of reaching a very delicate political compromise on an issue like that if you actually think the president is just going to, simply benevolently suspend those portions of the law he doesn't like after you reach that compromise? So if you want to stay relevant as an institution, I would suggest that you not stand idly by and let the president take your power away.
As Mr. Schroeder has noted, the president certainly has some discretion to set enforcement priorities in order to best allocate limited resources and to make a case-by-case enforcement decision. But does that discretion encompass the complete non-enforcement of multiple statutes without any argument that they are unconstitutional, Ms. Foley?
You're talking about the just discretion to not enforce something? Could you repeat the question? Because
Sure.
I got a little long there around the margin.
I apologize, but
Right.
we acknowledge, as Professor Schroeder noted, that the president has some discretion on case-by-case enforcement decisions, but the question is, does that discretion encompass complete non-enforcement of multiple statutes without any argument that they are unconstitutional?
Yeah, of course it doesn't. There's a difference between enforcement discretion